Thank you, Your Honor. May it please the Court, I'm Michael Thorne, Thorne is the Honor, representing the appellant, James Healey, and this actually reserved 3 minutes. This case presents 2 issues to the Court. The second issue is fairly straightforward, and I will not spend a lot of time on it, but it has an impact on this case. Of course, this case presents a modification whereby Mr. Healey sought a substantial reduction of his $10,000 per month alimony award, which had been agreed to in 2004, stipulated final judgment. Why did he ask for it? He asked for it because the income that he would have been earning at the time of final judgment, in excess of $520,000, had been reduced by the time of trial to $50,000, and there was no evidence whatsoever to dispute any of those facts. The second issue was the trial court's use of discretion in failing to reopen the case to permit additional evidence to present that even the $50,000 annual income that he was earning from the CBS outdoor job had been eliminated because he was involuntarily terminated for no reason, no fault of his own. The trial court refused to allow that to be reopened. There was no reason for that to happen. The court was still waiting on written submissions from the parties, and the court took 7 months thereafter to rule. There, in and of itself, is an abuse of discretion which shows why this case required reversal. But I want to focus the majority of my time this morning really on the merits of his petition for modification. What we have here is a situation where we have a payor, a husband, who is land rich and cash poor. At the time of the final judgment, he was an owner, 1/3 owner in this Mint magazine, and we briefed that extensively. And there was a tremendous amount of testimony at trial about the destruction of that business and the interaction between he and the other 2 partners. Well, here's what was undisputed. Even the trial court ruled against us, found that when he left Mint, it was involuntary because of the intractable differences he had with the other 2 partners. It's also important to recognize the partners he had were his previous competitors. It wasn't until 1991 that Mr. Healey on one hand, Mr. Flynn and Mr. Cathy on the other hand, decided to join forces because they were tired of beating themselves up in the marketplace. So this was never a marriage of lovers, it was a marriage of convenience, which worked well for a period of time. Unfortunately, at the time that the business was sold, as the record reflects, without any knowledge of Mr. Healey, they generated a lot of money. There's no question. There was a gross of $3.1 million which he received, which after taxes got to about $2.6 million.
Well, what is the effect of your clients having valued this at $1.8 million in the original form? In other words, the thing was worth almost twice as much as what he said it was worth.
Total red herring, and here's why. First, there was undisputed testimony, even by Flynn, no friend of my client, who said we had always agreed to conservatively value the Mint shares. And the reason, as testified both from Mr. Healey and from Flynn, was that there were complicated buy-sell provisions in their shareholders' agreement. So in other words, there was not an open market for those shares. If a shareholder wanted to dispose of those shares, he had to offer them to the other 2, and there were specific target prices for those shares.
That's an issue, though, between the owners of the company. I mean, as respects these parties to this case, if you file a financial affidavit and say the thing is worth $1.8 million, the judge is going to make some decisions based on that. To put it another way, if Mr. Healey had said initially that this is worth $3.1 million, maybe the judge would have awarded more than $10,000 a month.
Well, the reason there wasn't an award, Your Honor, it was a stipulated mediated settlement. So at the point I agree, we have to assume that Mrs. Healey had every opportunity. This wasn't a case that just went out of the box.
So you're saying she knew it was grossly undervalued, too?
Well, or she had the opportunity to find out, but it was not grossly undervalued. I want to come back to the other reason.
I didn't mean to put words in your mouth there on that.
I understand, Your Honor. In addition to the restricted aspects of the buy-sell between the 3 Mint shareholders, there was approximately a 20-month difference between the time that Mr. Healey put that 1.8 on the financial affidavit and the time that the sale took place. And there was undisputed testimony about what had occurred in the marketplace, specifically issues relating to the Tampa market, where the 3 of them had invested upwards of $1 million in trying to develop that market. And now we don't have a buyer who is one of the 2 other shareholders under a restricted agreement. We now have Gannett. Gannett is now the buyer. Gannett wants to buy them out. Gannett sees that if we get rid of Mint in Tampa, we have a substantial market share. And so they pay a premium for it. And so, Your Honor, with all due respect, that was a red herring issue. It had nothing to do with anything. What has something to do is, as the case got tried, it was tried on a net value, a net worth. Well, look at Mr. Healey's net worth. network. What did he do with the money from Mint? He was restricted by 2 non-competes, so he couldn't do what he had always done for 20 years, being the advertising business. He had a non-compete with the first 2 guys, Flynn and Cathy, way back when they first did the 1991 Mint deal. He then had a subsequent non-compete when he then buys them out in 2005. So he's now restricted for at least a significant period of time, and there's issues about the non-compete we'll talk about in a moment. So what does he do?
Was the husband's subsequent representations in these loan applications also concerning his net worth also a red herring?
It was, I wouldn't call it as red herring as dealing with the valuation of Mint that the judge had. I don't talk about. It was an issue, and it was practically Judge Lewis was the only issue that this trial court relied upon, because they said, well, we just don't think that Mr. Healey had candor, because they pointed out some discrepancies between some of the financial statements that were submitted to some banks when he was buying the properties where the $3.1 million went, because it couldn't work. So, I mean, in candor, I would say it is a somewhat different level than the valuation that we talk about with Mint. Were there errors on the affidavit, on the financial statements? Yes, there were. But what was the best evidence of the income? The best evidence, as even counsel stated during trial, was his tax returns. And the tax returns show what his income was. And, you can't eat real estate. You can't eat the land. It may be worth something, but it's only worth something if you can sell it or you can produce income from it. And so what does the testimony present here? There's no findings about his income. You will look in that final judgment, you will not find one. There is no finding as to what this man is earning at the time. Over an extended period of time, the case was tried for months, and then, as I said, it took 7 months after submission to the court for entry of the judgment. You won't find a finding. We pointed out in the motion for rehearing, which was denied, and then in our brief, that there was no findings of fact that show even that he's got the ability to pay. The court simply said, and focusing Judge Lewis on your comment, said, well, we have this problem with these financial statements. I don't know if I can believe. But what you could believe was the tax returns, which showed his income steadily reducing to the point that by 2008 his income is in the negative. And so alimony is supposed to be a mechanism by which cash can be paid by someone with the ability to pay it to someone who needs it. Now the issue, I'm sorry.
As I understand your argument, you argue that the trial court failed to consider certain evidence in the proceedings below. But isn't it true that all other evidence became basically irrelevant once the trial court determined that the husband was in no credible evidence of his current income?
Well, that finding is not supported by the record, Your Honor. Here's what his income was, and this testimony is undisputed. It's $50,000 a year from CPS Outdoor. He had $10,000 of income from director's fees, which was the director of the very bank that they complained about that he was supposed to be giving misstatements to. And he received about $10,000 in the last year of rental income from those properties. The income that he showed was $74,500. That's what the evidence showed, and they presented no evidence whatsoever to the contrary. If you scour that transcript, you will not find any testimony elicited by the wife that was in any way contrary to what his cash is. And so we have a situation where
is the trial judge entitled to disbelieve your client? I mean, you made an interesting comment in your brief. You said the trial judge found a lack of candor on the part of your client, but that finding wasn't supported. Do we require judges to prove why they don't believe a witness? I mean, a judge has the right to say, I don't believe you, and that's pretty much the end of the story.
Well, when the wife presents no testimony whatsoever to rebut the income issue, because, as I said, it is a partial red herring, Judge Lewis, it doesn't go to the issue of what this man's income is right now. I mean, he could own, the building next door and the building next door, but if it's not producing cash, and he can't sell it, and the evidence was undisputed that most of these properties were on the market at a lower price, and he had continued to reduce the price because the reason he got into this business in the first place was to try to buy properties. This was in 2005, in a much different market than we're dealing with now. And it's very easy for us now to sit back and say, wow, bad decision, Mr. Healey ought not to have done that, should have done something different with the money. Well, that's all well and good, but the Outlaw case cited in our brief says, probably business decisions don't rise to the level of fault.
But counsel, are you asking us, this panel, to reweigh the evidence concerning the husband's misrepresentations on the loan application?
I'm saying that they could be considered, but they do not carry the day on, because there was other undisputed evidence as to his income. And that's really what the trial court, unfortunately, was distracted or put aside on the issue of what income is. That's what we're talking about. We're not talking about whether there should be some subsequent equitable distribution. We're not talking about any other issues other than, does Mr. Healey have the current ability to pay $10,000 cash money every month to the wife? And we showed at trial that he has no ability. How has he been doing it? This is not a man who just said unilaterally, no, can't pay it, not going to do it anymore. And we see that, unfortunately, a lot. He has paid every month. How has he done it? He's borrowed over $400,000 at the time of trial 2 years ago. Do the math as to where that takes us. He's kept faith with the order. He's kept faith with all the obligations in the judgment, but at what cost? The cost is he's now further in debt. His mortgage, his property is even further mortgaged. And the case law, Cathy and the McIntosh case cited in our brief says no party is required to either dispose of capital assets or borrow money to pay a periodic support obligation. That's just black letter law. And that's what the case should be focused on. Judge, we're not asking you to reweigh the evidence. We're asking you to go back and tell this court, make a finding about what his true income is. Let him show you what his income is, his current employment situation truly is, which he didn't allow him to do even at the close of the trial. There are no findings of that.
The finding of lack of candor is not enough. I mean, what I'm worried about is if we agree with you, we're going to write an opinion that says what? If the judge says he or she does not believe a witness, then you have to justify that, you have to explain it, you have to prove it. I hereby prove that I don't believe. I mean, it seems to me a judge can just say, I don't believe you, and that's the end of the story, isn't it? I mean, you know, and I'm not talking about, we have to put this whole thing, this whole case together. We're talking about a situation where you have a man who's in business, apparently very successful business over the years. People in those situations have a much greater ability to hide income if they're inclined to do that. I'm not saying your client did, but let's just say compared to somebody like me, every penny of the money I make, you know, I mean, I couldn't hide a dime of it if I wanted to. But people who are in business, and judges know this, I mean, they're not foolish. This is a harder case for a judge to try. And if a judge says, look, I think that you really have the ability, and I think you're not being truthful with me, why isn't that the end?
Because, Your Honor, you still have to make findings to support that. And we submit that there were no findings to support that. There were no findings that would go beyond the I just don't believe you. But the I don't believe you has got to be weighed by years of tax returns as opposed to mistakes that were made, and not all mistakes on those statements, by the way, by him. There was even undisputed testimony that the bank messed up a couple of those applications. They made a big deal about the fact that the marital home was listed on one of those statements. Well, the reason it was listed is they picked it up on a credit app because the mortgage is still outstanding, and he's still obligor on that mortgage if the wife doesn't pay. I mean, it's my rebuttal time. I will certainly try to address further your concern about where an opinion might take a court.
May I please report? I'm Corinne Violence, appearing to be Appellee, Cathy Healey. I'd like to address the issue of my motion for appellate attorney's fees, actually. I had missed the deadline by 3 days, and appellants filed an objection, and the court said that they would consider my motion at this time. So I wanted to refer the court to a few different cases, the first of which is Healey, which is a Supreme Court case from Florida, 511 and Southern 2nd 975, which states that a motion for attorney's fees can still be considered if it is filed after the deadline, which is motion for a hearing date. Now, I just wanted to be straight with the court that that case was reversed insofar as the court clarified in the case United Services Automobile Association, also Supreme Court case 775 Southern 2nd 921, that if a motion for appellate attorney's fees still doesn't meet the substantive requirements of 9400B, that it should be ruled out. Finally, I just wanted to cite the case of Kaloios, K-A-L-O-Y-I-O-S, which is 967 Southern 2nd 1035, in which the court stated public policy in Florida favors deciding controversies on their merits. And in this case, it was a brief that was filed late. Even when an initial brief is untimely filed, the appellate rules allow for extensions of time for most steps in the appellate process, including for the filing of briefs. And it also goes on to say that the court has discretion on whether or not to rule on these matters.
Now, in that regard, in Florida Department of Commerce Division for Risk Management versus Davis, cited at 379 7 1313, this court held that all future motions for appellate attorney fees that did not comply with the Florida rules of appellate procedure 9.400 would be denied. Is Davis still the law?
I'm sorry, what was the site?
Florida Department of Commerce Division of Risk Management versus Davis, cited at 379 7 1313.
Okay.
It's a 1980 opinion from this court.
Your Honor, I would say that that ruling would not be good law anymore because the cases that I cited that say that the court will accept a motion for attorney's fees after the deadline is expired, and the case law that said that that motions for attorney's fees that don't meet substantive requirements would be stricken. Those are 2002 and 2000. And those are
What was the reason for the untimeliness of this case?
It was just inadvertence.
So your inadvertent argument is your response to the former husband's argument that you were just sandbagging?
No, I was not sandbagging. I just missed the deadline. It was just a mistake. 3 days after the deadline, it was just a mistake. And
well, on the merits of the case, will you address the arguments that you look at the tax returns, his income has obviously been devastated by the real estate downturn, and it seems the trial court may have just decided, well, these loan applications, you lied about your income, or I guess she said, I think you were telling the truth in the loan applications about your income, and it's greater than maybe she implicitly found he lied on his tax returns.
Right, and the problem in this case, for the former husband, frankly, is that none of the evidence regarding his income was consistent. The tax returns, were what they were, but I cited the cases of Ugardi, Johnson, and Wolf that say that when somebody is self-employed, the tax returns are not always the best reflection of what that person makes. And as Catalano pointed out, that when somebody is independently employed, it's not the same as somebody who's a W-2 employee where you can track all of their money. So the court needs to look at other things. In this case,
that's my question. What's the other evidence on income?
The other evidence were several sworn statements signed by the former husband that were brought into evidence by the former wife. There were several of them in the former husband's own handwriting. There was one dated January 15, 2005. It was former wife's exhibit number 2, where he claimed in his own handwriting to own the marital residence, that after the judgment was entered. That's not just a simple mistake.
I guess what my question seems to be getting at is, let's assume for which I think you have a good argument we can assume that. Let's assume those false statements were made knowingly by him, and that the trial court had a right to rely on them to a certain extent. Some of those statements, as I recall from this case and the briefs, are getting loans, right, on his real estate?
Yes, Your Honor.
And those loans on that real estate are in part used to pay the $120,000 annual alimony, right?
Well, Your Honor,
Is that right? I'm just going to...
I don't know what he used those loan proceeds for exactly. That is certainly what the former husband is claiming. But
let me try it this way. Where is the income stream here? Other than from indebtedness on the real estate and some of the remaining proceeds from the sale of the magazine.
Good question. Good question. It was the former husband's burden to prove what his income was, and he
But
didn't
aren't
do
tax
it.
returns,
And
aren't tax returns at least prima facie evidence that here's my income made under threat of federal imprisonment? I mean, I understand the case law says.
he lied under oath on several sworn statements. What makes the court think that he wouldn't lie under oath on a tax return?
But is it clear, counsel, that the former husband did suffer some amount of reduction in income when he lost his job at Ghana?
Maybe. Maybe he did, but was it substantial enough and material enough to make it so that he couldn't pay $10,000 a month in alimony? I think not. The former husband's financial affidavit submitted in this case, the one he submitted when he filed and the one he submitted shortly before trial, only showed a $16,000 increase in his net liabilities. So over the span of 1 year, he paid all of his wife's alimony. He paid $30,000 a year towards the children's school expenses, $60,000 a year towards other expenses towards the children, which he wasn't going to have to pay anymore, and still his income his debts only increased $16,000, all the while he was fully financially supporting his live-in girlfriend. And I took some heat on that argument in my answer brief in appellant's reply brief, and I apologize for the use of the word paramour, but this man started living with her a little bit before the final judgment was entered, which is fine, and he can have a girlfriend, but he can't support that girlfriend and then say he can't pay alimony for his wife. The trial court is in the best position to determine the credibility of the witnesses, and sometimes in trial, magic happens. Magic that can't come through in a transcript. And there were moments in that trial when magic happened. The trial counsel for the former wife was cross-examining the former husband's girlfriend. She was subpoenaed to bring her tax returns with her. She brought them in a folder. During her testimony, she referred to that folder. And in that folder, there was a fact cover sheet that appears in the record, volume 11 at page 2038. And that fact cover sheet is where she was asking her CPA. She's saying, attached to my K-1 with a loss, I have received no 1099s. I have zero income. My boyfriend has been supporting me until my business gets off the ground. Can he take me as a write-off or dependent? What needs to be filed? Is it better to have paid him back some money? Business will be profitable this year. And she's referring to the business that she entered into with the former husband. And it was things like this happened all during the trial. The former husband wanted to say that, the business was valued at 1.8 when the parties had their divorce, and, that ship has sailed. But it's not a red herring in the sense that it goes to the former husband's credibility as to all his statements regarding his finances. Okay, for the purposes of my divorce, my business is valued at $1.8 million. Okay, a couple of months later, in January of 2005, he puts on a sworn statement in his own handwriting that the business is worth $2 million, not 1.8. Well, what's $100,000 when you've got millions?
But counsel, is the trial court required to make a finding of the amount of income each party has when making a decision concerning alimony?
Your Honor, under these circumstances, I think not, because it is the former husband's burden first to show that a substantial material, unanticipated, involuntary, and permanent change of circumstances has happened. Okay? That's number one. Okay? He can't prove that. You don't get to the balancing test on need and ability to pay. But even if you did get to the test on need and ability to pay, you can look to the former husband's own bank statements that were entered as the former wife's exhibit regarding his bank deposits that were showing bank deposits of between $16,000 and $30,000 a month. So You can also look to his financial affidavit, which says that he's paying $10,000 a month in alimony. He's paying all these expenses for the twins that are now emancipated, and that those expenses have gone away. And he's fully supporting his girlfriend, and his debts have only increased $16,000. So you're at an abuse of discretion standard where the appellate court will not reweigh the evidence. And if a reasonable person could conclude that it was more than $16,000 of support towards the daughters, or more than $16,000 of support towards the girlfriend, either one of those, if a reasonable person could conclude that, and I say they could, then the trial court's holding that, or finding that he has the ability to pay stands, because nothing changed. Now, on the motion to reopen the evidence, that was irrelevant, okay?
Counsel, in regard to that issue, what prejudice would the former wife have suffered had the trial court reopened the case, or reopened the evidence?
Well, she would have had the prejudice of evidence coming in that is more prejudicial than is substantive towards the nature of the action. He's trying to say, oh, my income just decreased suddenly $50,000. But that income wasn't there when he filed his supplemental petition. So what's changed? No $50,000 to no $50,000. That's not a change. Furthermore, there was no finding in the final judgment that said that the court even considered that $50,000 was income to him. There was no finding that said that the trial court based their ruling on the $50,000 in income. The husband was inconsistent by hundreds of thousands of dollars within days of each other, sometimes, on his financial statements, okay? He was inconsistent regarding the valuation of his business, okay? What's $100,000? What's a couple million, when the business is valuated at almost double a couple of years later? He has foreign financial statements that say that he has $150,000 and $140,000 in rental income. And now all of a sudden, when he's in the midst of litigation, he's all of a sudden stating that his income is only $15,000 from his rental properties. Nothing's changed. They say net income $140,000, net income $150,000, net income $15,000. After you've been deposed and it's been pointed out to you that you had $140,000 and $150,000. But, to him, what's $150,000? What's $140,000? In his mind, on his financial statements, he bounces back and forth that amount all the time. His financial affidavits indicate that he has the ability to pay that $10,000. He has the ability to keep paying the $10,000, and he has the ability to keep paying for his girlfriend to live with him at the same time, because he was paying more than $16,000 a year for his daughters who have now aged out. So the trial court's findings were completely supported by a competent, substantial evidence that was in the record. It is a large record, but it is all there. And one thing that I love about defending final judgments written by this particular judge is that she puts in all the findings that you need. She footnotes it like crazy and even cites case law. It's all right there for you to affirm the judgment. Thank you.
I think we just saw the magic. This is what happened at trial. We didn't focus on income, we focused on net worth and bank statements. This is not what the case law says it's supposed to be focused on. A couple of points, and I just have to point them out. They're in the brief. Because, when she says that he had 140 of income from the receipts of the rent, that was the gross. There's debt service, there's insurance, there's utilities. The income was a negative. In most years, it only was a $10,000 income from the rentals in 2008. This is not a Ugarte case. I'm very familiar with Ugarte. I've argued it plenty. This is not a situation where, like the Epstein case we cited in our brief, where there was bad conduct going on. At worst, it was sloppy, and he even said there were 40 pages in the transcript where they laboriously go through, not only on direct but on cross, all of those statements. And he showed what happened. They were either sloppy or they were bank error, but they don't prove ability. And for counsel to argue that...
What about the argument your opposing counsel makes in that until you carry or meet the burden of persuasion that there's been a change in income, you don't get to ability to pay?
Well, the ability, I think that was clearly met, Your Honor. I mean, he presented all of the testimony necessary through the tax returns, through his testimony, through the testimony of the failed aspect of the ability to flip these properties, which he then had to rent. He didn't want to re-rent them initially. He said, I wanted to buy them, fix them up, sell them. Market tanks, well, I got to do something with them because I'm under those non-competes. And as far as the final judgment in this case, this trial judge is generally known for a good judgment. There are outliers in the world. This was one of the outliers, I have to say.
Counsel, you didn't address the issue 2 presented on appeal in this case regarding the trial court's failure to reopen the evidence. But isn't it clear that the trial court's order that the husband's employment with CBS did not enter into his decision? Didn't that move the need to reopen the evidence in this case?
Judge, if anything, I think it presents even a bigger concern. The court is now, the court is saying your current employment status is irrelevant for purposes of determining a modification of your sport obligation. The income you are earning is no longer a consideration and not relevant to determining your ability to pay. I can't imagine anything that was, if this was irrelevant, I would have expected counsel to argue and object to any evidence about CBS Outdoor in the first place. Say, well, it's irrelevant that they're working because we're focusing on the net worth, which, again, you can't eat net worth. So, Your Honor, I cannot conceive of a more problematic issue than ignoring the reality. Don't confuse us with what happened. Let me just tell you all this. This is not a bad man. We respectfully request that the court reverse. I understand Judge Padovano's challenge with respect to how you craft it, but I think what you do is you look at it first saying by July 2008, this man had in fact proven up a substantial change in circumstances, and he needs to have a substantial reduction retroactive to that date. My time has expired. I will rely on my